We will now begin our second panel, Understanding AI's Prospective Buyers and Housing Markets. Professor Humber, a professor at our very own University of Connecticut School of Law, will serve as our moderator. Take it away.
Welcome, everyone. Thank you so much for being here. My name is Nadia J. Humber, and I am an associate professor of law here at UConn. I teach, for those of you who don't know me, I teach property law, race and the American legal system, and housing discrimination law, all topics that are very near and dear to my heart and that I find just so fascinating and interesting. I have had also the pleasure and privilege of advising on the symposium, and so I'm just so glad to just see so many of you in the room. So this is our second panel, Understanding AI's Effect on Tenants, Prospective Buyers, and Housing Markets. And so we were going to have 3 panelists today, but I just wanted to inform you all. Dr. Michael Akinwumi was one of our panelists. He is from the Chief AI Officer at the National Fair Housing Alliance. Unfortunately, there was a travel issue, so he could not make it here today. And so we are going to attempt to find some alternative ways for him to engage with you all, whether that be a recorded lecture to share with you or perhaps shared materials. We will be in touch about that. So just to inform you all regarding our panelist structure today. But we do have here our fabulous speaker, Attorney Mark Epstein. Attorney Epstein is Senior Counsel for the Digital Initiative of the Lawyers Committee for Civil Rights under the law in Washington, D.C. Attorney Epstein litigates cases concerning technology and racial justice. His practice includes consumer privacy, algorithmic bias, discriminatory advertising, election disinformation, and free speech, among other essential issues. And so Attorney Epstein will be discussing with us a survey of AI housing cases, as well as some broader issues regarding litigating AI bias and just general AI policy priorities. And what kind of panel would we be talking about AI and technology if we didn't have a virtual speaker? And so our next speaker is coming with us virtually, Dr. Erin McElroy. So Dr. Erin McElroy is a legal scholar, activist, and assistant professor of geography at the University of Washington. Dr. McElroy's work focuses upon intersections of gentrification, technology, digitality, empire, and racial capitalism in the US and in Romania, alongside justice organizing, counter-mapping, and transnational solidarities. Dr. McElroy will be discussing with us today some of the implications of facial recognition technology in public housing. So we are thrilled to have both of our speakers here today, both in person and virtually. And so from there, I will turn it over to our first speaker, Attorney Epstein.
Good morning. Thank you, Professor Humber, and thank you to University of Connecticut and Law Review for having me here to speak on such an important issue. It's really a privilege to be here. As Professor Humber mentioned, I'm going to speak about algorithmic bias in housing. So if you'll bear with me for just a second, I'm going to step away from the housing part of this to talk about the algorithmic bias aspect. And then I'll bring it back into housing and show you how pervasive it is across all aspects of housing and what we can potentially do about it. So let's start by defining algorithmic bias. Algorithmic bias, at least one definition, is systematic and repeatable errors in a computer system that create unfair outcomes, such as privileging one category over another in ways different from the intended function of the algorithm. And That's not necessarily unlawful. Unlawful algorithmic bias or algorithmic discrimination occurs when the privileging of categories occurs based on protected characteristics such as race, sex, national origin, or religion. And there are lots of reasons why algorithms result in bias. One of the main reasons is because they rely on data that is already biased. And Richard Rothstein really did my work here for me already and explained how centuries of institutionalized discrimination, from slavery to segregation to redlining to disenfranchisement, are all still pervasive today. And I have on the screen, I think you can see, a quote from Fourth Circuit Chief Justice Gregory, who wrote that the effects of discrimination continue to divide society in investment in construction, urban blight, real estate sales, household loans, small business lending, public school quality, access to transportation, access to banking, access to fresh food, life expectancy, asthma rates, lead paint exposure rates, diabetes rates, heart disease rates, and the list goes on. And the reason I'm putting this quote up here is because algorithms, especially many of the algorithms we're going to talk about today, like social media algorithms, they scoop up data from across society. Everyone here has probably seen a cookie notice on most websites now, asking you whether to reject or accept personalized cookies for advertising. But that has been going on for a long time, and they take data about everything, and all of it comes from a society with systemic inequality. And a good example of this, and all these algorithms reproduce and amplify the discrimination that is inherent in society. And a good example of this is algorithms that we're going to talk about today, which are those that use credit scores. And it's well documented that Black consumers have lower median credit scores than white consumers because of generations of discriminatory practices that have impeded the accumulation of wealth. And the algorithms that then use credit scores and also use other data amplify the imbalances that are already inherent in credit scores. Many other issues lead to algorithmic biases as well, including underrepresentation of women and people of color in tech, because of everyone has their own implicit biases, and if those aren't checked at tech companies, then they'll result in algorithmic bias. Inaccurate data in data sets, and overrepresentation and underrepresentation of different groups in data sets. And then, even if you account for all of these issues, algorithms that don't have proper safeguards, which we'll talk about later, can still result in discrimination. So let's move on to algorithmic bias in housing, and I'm going to talk about a bunch of different cases in all facets of housing in just a second. But let's talk about a few themes before I do, so you can look out for these themes while I'm talking about these cases. And the first, as I've mentioned already, is the pervasiveness of algorithms in housing. The second is the use of traditional civil rights laws to combat algorithmic discrimination. Now, we're here speaking about housing. It is one of the most active places for algorithmic discrimination litigation. And that's because of the Fair Housing Act. And our last panel really spoke about how we shouldn't take the Fair Housing Act for granted and how strong disparate impact coverage is. Most civil rights laws do not provide disparate impact coverage. And that's why the Fair Housing Act is so important, and why inclusive communities was such an important decision for us. There are many other civil rights laws, like Title VII, which does provide disparate impact coverage, ECOA, which arguably provides disparate impact coverage, depending which circuit you're in, Section 1981 and 1982, which do not provide disparate impact coverage, Title II, which prohibits discrimination in places of public accommodations, which does not prohibit disparate impact discrimination. And then there are also state laws, and state laws are a really important resource for civil rights litigation in this area. There's also the use of other laws, like consumer protection laws, and you'll see that in the cases I'm about to talk about. And I'm also going to show you that there are a lot of hurdles to relief in each of these cases, and some of these litigants have overcome those hurdles, and others have not. One of the biggest hurdles for algorithmic discrimination is black box algorithms. So most companies, most algorithms are proprietary. You don't know what goes into them. So for disparate impact liability, before we discuss how you need to have a neutral policy, well, how do you know what the policy is if you're looking at the algorithm, if you don't know what goes into the algorithmic sauce? We'll also talk about how a lot of algorithmic discrimination doesn't fall within the scope of laws. We talked about how the Fifth Circuit kicked a case on standing. Well, standing is a huge impediment to civil rights groups bringing cases dealing with discrimination. Constitutional barriers like the First Amendment, which isn't so much a big deal in housing right now, but Section 230 of the Communications Decency Act for algorithmic discrimination is. So we're going to move on to the actual cases now. The first, and I've divided these up into different areas. The first is tenant screening cases, and one of those cases was mentioned before, Louis v. Safrent, and we're going to talk about that in a second. But let's first talk about what tenant screening actually is. Tenant screening companies obtain and analyze information about applicants from sources and then generate a report about the person that's being screened, often including a recommendation of whether to accept or reject the applicant. And then housing providers then use these reports to determine which applicants to accept, deny, or accept with some additional fees or conditions. So the first case is Connecticut Fair Housing Center v. CoreLogic, which there might be some people from Connecticut Fair Housing Center here that know this case much better than me, so I apologize. If I get anything wrong, you can just shout it out. And in this case, a mother applied for a son to move in with her. He had just had a traumatic brain injury in an accident, but his application was denied because he was arrested in another state at some point and charged with minor theft. And they sued the housing provider and the background screening company that the housing provider used to check his criminal history and credit worthiness. And they brought claims under the Fair Housing Act, the Connecticut Unfair Trade Practices Act, for both disparate treatment based on race and national origin and disparate impact. They also brought claims under the Fair Credit Reporting Act for failing to disclose consumer report upon request. And that's a good example of using other laws in conjunction with traditional civil rights laws. And I'm going to spoil the story here for you. The plaintiffs win on the Fair Credit Reporting Act claim, but not the. And so the framing of the disparate treatment claim here is that the defendant was aware of HUD regulations that govern the use of criminal records in tenant screening decisions, the racial and ethnic disparities in the criminal justice system, the effects that the automatic denial of housing based on criminal records have on minorities, and less discriminatory alternatives, and then continue to offer its crim-safe product. And the facially neutral policy, which often is pleaded in the alternative, is of making automated determinations in an applicant's eligibility for tenancy without providing the underlying documentation or conducting an individualized assessment of the applicant. So this case actually went all the way through a bench trial, which is pretty unusual in most cases. I'm sure you've all learned most cases settle long before they go to trial. And though it survived the motion to dismiss prior to that, the district court held that that CoreLogic, which was the provider of the tenant screening the tenant screening algorithmic tool, was not subject to the FHA. The reasons are because the housing provider controls the they said the housing provider controls the disqualification process, and that no one could believe that CoreLogic makes housing decisions for them. And this implicates another theme that I was talking about before, which is that sometimes courts will hold that the defendant is not within the scope of the civil rights law. The next case I'm going to talk about comes to the opposite conclusion. And so in the next case, Louis v. Safe Rent, the prospective tenants were black women with housing vouchers who applied for housing, and they were denied because the housing providers relied on their Safe Rent scores, which relies on credit histories and other factors such as bankruptcy records, past due records, payment performance, and eviction history, and did not take into account housing vouchers. And here, this case, the district court granted the motion to dismiss as to some claims, but not as to the Fair Housing Act claim. Now, this was really interesting for a few reasons. First of all, the court distinguishes core logic because this is a motion to dismiss. I think most of you have taken CivPro already, so you'll know that the burden is going to be higher at summary judgment or after a bench trial for sure. But there are also some really interesting differences between core logic and Safe Rent. In core logic, they provided a score, I believe, for the different tenants. In Safe Rent, they actually say to the landlord, yes, no, and that's basically it. So it's pretty undeniable that they're making housing unavailable for the renters. Also, the prospective tenant requested an appeal of the decision, and the landlord said, I can't do anything, it's out of my hands. Safe Rent said, no, that's it, which again shows you that it's Safe Rent's decision unilaterally, according to the housing provider, to make this decision. This issue was then taken up by HUD in guidance that it issued in April 2024, and I'm going to talk about two HUD guidances. One is on tenant screening, and one is on advertising and housing in a little bit. And HUD basically says that these tenant screening companies should be covered by the Fair Housing Act because the Act permits entities to be held liable when they have personally committed or contributed to a Fair Housing Act violation. In other words, if their conduct results in a discriminatory housing practice. Thus, a tenant screening company can be held liable under the Act for facilitating a discriminatory decision, even if the housing provider makes the ultimate decision as a formal matter. They also disagree, maybe not explicitly, but theoretically, with other logic in core logic, which they say the screening report does not need to direct the housing provider explicitly to accept or deny the applicant to have that kind of influence. As a practical matter, it often is sufficient that the report provides a score, a recommendation, or any other sort of explicit or implicit opinion. So it provides a bunch of recommendations for housing providers and tenant screening companies to implement to make their algorithms Fair Housing Act safe. I'm going to skip over those for now, but just briefly, a few of them will talk about transparency, impact assessments, training the model correctly, and these are things I'm going to talk about at the end. Another category is in mortgage lending, and there are a couple of cases out there. In 2022, Bloomberg reported that Wells Fargo's mortgage refinancing algorithms rejected over half of black applicants while approving over 70% of white applicants. And Wells Fargo also charged black borrowers higher interest rates and imposed higher costs and fees. There are several class actions pending. And there was another report by this incredible news outlet called The Markup, which showed that lenders were 40% more likely to turn down Latino applicants for loans, 50% more likely to deny Asian Pacific Islander applicants, and 70% more likely to deny Native American applicants. Lenders were 80% more likely to reject black applicants than similar white applicants. They singled out 7 lenders in particular. One of them was Navy Federal Credit Union. More reporting came out about Navy Federal Credit Union, and they were eventually sued. Moving on to homeowners insurance, there's a case I think it's in Illinois right now, where these individuals sued State Farm because their houses were impaled by hail in a storm, and they tried to get their claims covered by State Farm. And one of the plaintiffs had to speak with a State Farm representative over 50 times in order to get their claim covered, whereas their white neighbor had to speak to them dozens of fewer times. And as someone who has recently had bouts with insurance, I can tell you that every time you speak with an insurance, and I apologize if someone is here, it's nothing personal, but that is, it truly is traumatic, and I don't actually mean that tongue in cheek. It really is to have a claim like that, to talk with the insurance 50 times is actually traumatic. And in the meantime, their house was further damaged, and the attorneys investigating this claim, they connected with the plaintiffs and then conducted a survey, which I've spoken before about this, how algorithms are black box, and this is, I think, really brilliant what they did, because the State Farm is using an algorithm in order to determine whose claims to move on and whose claims to process right away. But you don't know exactly how that algorithm is working. So they conducted a survey of 800 State Farm homeowners and found statistical significant deviations between how black homeowners' claims were processed and how white homeowners' claims were processed. So instead of studying the algorithm itself, they studied the output, the ultimate effects of it, and that was enough for the court. And the court has some great language in this case that I'm going to skip over for now because of time. But it does recognize that algorithms are difficult to study. The next cases have to do with discriminatory advertising. What you have to know, first of all, for these cases is that a lot of housing advertising is happening on social media now, of course. And the way social media works is that there's a targeting system and an advertising system and a delivery system. So the targeting system basically allows a housing provider to choose who they want to target with their ads. And Facebook used to actually let you exclude people based on race and sex if you wanted. So if I was a housing provider and I wanted to target my housing ad to only white people, it let you do that. And ultimately, the National Fair Housing Alliance and other civil rights groups sued and obtained relief for that discriminatory conduct. But even if you target people broadly, Facebook's system algorithmically chooses whom to deliver the ads to. And it was doing that in a discriminatory way as well. And so what would happen, for example, is that you would have a house in a white neighborhood, a predominantly white neighborhood, that a housing provider would maybe target neutrally across all races. And Facebook would see that it's in a predominantly white neighborhood and think, oh, this must be more interesting to white people. And then it would deliver the ad predominantly to white people, which is discrimination and unlawful under the Fair Housing Act. And so the United States, first HUD and then the Department of Justice sued Facebook and settled the case, I think 2 years ago. And the last piece I'm going to talk about is rental prices. And this is more of an aside. It's very interesting because this is an antitrust lawsuit, which shows you the breadth of different laws that you can use in order to deal with this kind of conduct. So this is a lawsuit by the Justice Department and several states against RealPage for an alleged scheme to decrease competition among landlords in apartment pricing and to monopolize the market for commercial revenue management software that landlords use to price apartments. Basically, there's a complaint that that RealPage tells landlords what to price their apartments at, and so they're all colluding. I'm going to move on to policy solutions, and I'm coming from a different, I think, point of view. This is going to be a privacy point of view that you would apply equally to both housing and other areas where algorithmic discrimination is an issue. And the Lawyers Committee, actually, where I work, released an Online Civil Rights Act, which contains, it's a draft bill that was actually adopted by Senator Ed Markey in his AI Civil Rights Act that he recently proposed. And it incorporates several different proposals that would help combat these issues. And the first is an anti-discrimination provision that specifically prohibits algorithmic discrimination and provides disparate impact coverage. The second is robust enforcement mechanisms. And again, there was an excellent question before about enforcement mechanisms. You need states, the agencies like the FTC, the FCC, and others, and you need a private right of action, because a lot of of what we're talking about was brought by fair housing centers and individual litigants, private in order to making sure that these laws are enforced. You need pre- and post-deployment assessments for both developers and deployers, and that's something that HUD talks about in the tenant screening guidance. You need a duty of care for developers and deployers of AI, requiring the products they offer to be safe and effective. You need transparency and explainability requirements so that consumers know when, how, and why AI is being used. And basically, that would allow you to have the facts in order to bring claims. So if there are transparency requirements, then you can look at those transparency requirements. They offer also reporting violations. And if you see that the report includes something that might be discriminatory, you can then use that in a lawsuit. And you need data minimization requirements, which would inhibit companies from just collecting and using as much personal data as they want. And that's it. Thanks.
Thank you so much for your presentation. So in similar fashion to panel one, we will have our next speaker present, and then we will have time for Q&A at the end. Take it away, Dr. McElroy.
Great. Can you hear me okay?
Yes, we can hear you.
You can hear me? Okay. Okay, just give me 1 sec while I share my screen so I can just get that over with. Well, it doesn't like that. 1 second. Okay. There's always some sort of technical thing, I know, even though we practiced this before. Okay, I think we're good. Can you see that?
Yes, we can see it. Thank you.
Okay, great. Well, thank you so much for having me here today. I'm really so sorry that I can't be here in person. I had intended to, but I appreciate all the accommodation that everybody's put forward to have me here virtually. And And yeah, thank you so much to everybody at the university who I've been emailing with for months now, who have been helping me figure out how to be here virtually. And thank you to everybody who's presented so far. I wish I could have been there in the morning, but I'm on the West Coast, so I couldn't get up early enough to hear everything, but it sounds like it was a fabulous day so far. But yeah, I wanted to say that, so for my talk today, I'm going to draw on ongoing collaborative research that I've been a part of for the last 5 years, in part through a project called Landlord Tech Watch. And that's a project that I run out of the Anti-Eviction Lab, which I house at the University of Washington, and which partners with the Anti-Eviction Mapping Project. So a lot of what I'm going to be discussing comes out of these partnerships and collaborations. And I'm going to focus on the incursion of facial recognition and other sort of predatory technologies in low-income housing, which I think really builds well upon the last presentation. I was going to actually explain a little bit about tenant screening, but now I don't need to. So thank you for that. And I also just wanted to say that I am not a lawyer. I have no background in legal studies. I am a housing studies person and an urban and digital geographer, but I come out of housing justice organizing and have been working in the space of fighting for better policy solutions in the realm of tenant housing, I guess, for the last 15 years or so. And a lot of that informs the basis of my own research and collaborations. But if there are questions about kind of nitty gritty things having to do with legal procedures, I'm going to lean on all of you because you all know far better than me about these things. Okay, so I'm going to begin. Okay, is this working? Okay, can you see the next slide? I'm just like, yes. Okay. So I am part of a collective called the Anti-Eviction Mapping Project, and I just want to ground a little bit of the presentation in that before I proceed with the part on facial recognition. The Anti-Eviction Mapping Project formed in 2013 in the San Francisco Bay Area. We now have chapters in New York City and LA, and some sort of nascent chapters in formation elsewhere. A lot of what we do is provide data, we write reports, we create tools, and we also do a lot of digital storytelling work with tenants who are facing evictions and gentrification, basically to provide information that could be more, that could help them in fighting their cases, whether that's a legal case or a direct action case on the ground. When we began, one of our main issues was that, and continues to be one of our main issues, is that most tenants these days don't actually know who their landlords are. This is not the case in public housing, but in privately owned housing, in the aftermath of the 2008 foreclosure crisis and the absorption of a lot of single-family rentals by Wall Street landlords, increasingly we're living in this age of corporate landlordism and corporate ownership of housing, and many buildings are owned by shell companies or limited liability companies or limited partnerships, and tenants are increasingly paying their rent to these LLCs and not necessarily knowing who their landlords are, which can sometimes be a problem. This is a tool that we make called a Victor Book. It only works in San Francisco and Oakland, but we're in the middle of expanding it. There are some similar tools. There's one in New York City made by a group called by Justix NYC, and I have a tool called Who Owns What NYC. But what this tool allows tenants to do is look up their address and then figure out what the sort of web of corporate ownership is behind that address, and all of these different shell companies and properties and financial transactions kind of behind the scenes taking place in terms of who their landlord is. And in the case of some buildings, like some landlords, all of the buildings that they own. So Veritas currently is the sort of largest, and often people will say the most predatory landlord in San Francisco. They also own properties in Oakland, also in Los Angeles, and probably elsewhere. But it's really, you can't just, make a request to the city to ask what are all the buildings owned by Veritas, because they're all technically owned by different LLCs. And so when you look at assessor data, when you look at even Secretary of State data, it becomes, unless you mash all this data together, it's really hard to know what are all the buildings technically owned by Veritas, which is the parent company for these shell companies. But that data we found is really important in organizing tenants, building tenant unions and bringing tenants together to fight corporate landlords, including Veritas tenants who have back in 2018 began suing Veritas for different cases of harassment and are continuing to work with lawyers to litigate against Veritas today. So a lot of this is all to say a lot of my interest in studying landlordism and some of the abuses with landlordism kind of come out of this ongoing quest that I've been a part of now for about 13 years to uncover these corporate networks and understand who property owners are and kind of what their geographies look like and what's happening behind the scenes in terms of their ownership networks. And that would have been enough, but what we started to notice in the case of Veritas, in the case of other corporate landlords, including Invitation Homes, which owns property across the US, across California, is that not only tenants are tenants having difficulty understanding who their landlords are, but it's becoming increasingly difficult for them to communicate with their landlords at all. Invitation Homes, which includes Section 8 housing and low-income housing throughout the US, uses this company called Yardi, which maybe people are familiar with here. Yardi makes this platform called Rent Cafe, which is basically, it's considered a virtual property management platform that tenants in Yardi buildings have to use in order to pay rent or file maintenance requests. And Yardi also engages in tenant screening. They're creating these sort of like one-size-fit-all sort of packages that they sell to landlords and property managers so that Yardi can screen tenants. It can kind of manage all of the sort of requests that tenants have, so forth and so on. And as we just heard about in the last presentation, there are lots of harms associated with tenant screening. And, we're sort of on this sort of within this new frontier of AI being used to do some of this. And there are, of course, many problems that we're already seeing in terms of a faulty name matching and basically overmatching the names of people, tenants of color when it comes to tenant screening. Also just reproducing cycles of carcerality and housing precarity. Because if you've ever been evicted or incarcerated, it's going to be harder for you to find housing in the future vis-a-vis tenant screening. So we know about all of these harms because people have been fighting them for a little while now. But one of the things that we've been also noticing that I think isn't getting as much attention, but hopefully will get more attention in coming years, is that there are a lot of problems for tenants who just don't want to use these platforms or can't use these platforms, have trouble in terms of accessibility using these platforms. A lot of tenants are finding that property management becomes increasingly difficult in using these platforms. I just have some quotes on the right here about, if somebody refuses to use one of these apps, they can't actually include some of the amenities that are included in their lease. Somebody else here is just talking about how they have ongoing maintenance issues. But instead they just have to kind of continue to file them through these apps rather than just talk to a human. And I'm kind of getting all of this to say that, there's this growing and expansive landscape in which landlords and property managers are using this tech and have a bunch of data about tenants vis-a-vis tenant screening, vis-a-vis all of the data that tenants might input into platforms like Rent Cafe, or, there are other platforms like Appfolio that do similar things. It's not just Yardi. But, so landlords and property managers have all of this data that they don't necessarily use wisely, but tenants still don't even know who their landlord is half the time and are increasingly not even able to communicate with a human being if they do have an issue that they want to address in their home. And we've talked about this a little bit already, but there are, a range of lawsuits. These are just against Yardi and some of its own sort of shell companies when it comes to tenant screening abuses and the violation of the Fair Housing Act and also the ADA at times. There are also, the Department of Justice has been, working against Yardi and also RealPage, which was mentioned on the previous panel or in the previous presentation. But again, these suites of lawsuits technologies that tenants are having in terms of just wanting to, for instance, to be able to pay rent through checks, as people have done for a long time, but not being able to once these technologies get rolled out. And we did see a lot of, in the case of Veritas, which also uses ERD, a lot of this got rolled out during the pandemic under the auspices of contactless property management, but without enough foresight as to how that might make the simple act of paying rent less accessible for tenants. So, so that's my sort of prelude to get to the issue of facial recognition, which I know I haven't talked about yet, but that was what we were studying in Landlord Tech Watch for a while. That's what we were looking at in some of our work in the anti-eviction mapping project. In 2018, there was a pretty famous, now famous case about the landlord of a rent-stabilized complex in Brooklyn attempting to deploy what would be facial recognition heat mapping software in their 718 unit building, which is comprised of 2 towers. It's predominantly Black tenants who live in those buildings. And this made the news in part because of its absurdity, but also in part because tenants were really robust in their organizing efforts against the deployment of this technology. The landlord, Robert Nelson, as you can see, sorry, on this previous slide, had announced that to the tenants that their experience entering their building would be frictionless, meaning that they would touch nothing and only have to show their faces. So the idea was that this technology would be able to kind of recognize heat patterns on somebody's face and then know if that person was who they said they were, and then let them into their own home. And as tenants pointed out, there were already many CCTV cameras in this building. They didn't want this kind of new technology to be added on top of their existing kind of technologies, which included key fobs. And ironically, as tenants were organizing against this and trying to inform their fellow tenants in their building that this was going to happen and that there were harms associated with it potentially, the existing CCTV cameras took images of tenants organizing against new tech, and then the property manager slid these kind of color photos under the doors of tenants as a form of harassment, being like, "We see you organizing, stop." But luckily, the tenants didn't stop. They worked with different lawyers, with Brooklyn Legal Services, with local politicians, with media, with the AI Now Institute, which was where I was employed at the time when I was doing a postdoc in New York. And so I got to know 2 of the tenants in particular, who I consider friends and allies at this point, Trinae Moran and Fabian Rogers. They were floor captains and 2 of the main organizers organizing against this technology. And these are just some quotes from them, as well as another organizer at Taslim. And what I really like about these quotes here is that they're very aware that there are multiple harms associated with deploying facial recognition technology in tenant housing, in regulated rent-stabilized housing. In particular, they saw that this technology might automate processes of gentrification and carcerality. And so one of the big fears was that data captured in this new tech and existing tech that was already there could be used against them to detect, a really petty lease violation, for instance, maybe like not properly registering a guest, or putting garbage in the recycling, or having somebody's like pet pee on the sidewalk. But all sorts of fears started to percolate that that people might start getting penalized for really petty things that normally could become grounds for their eviction. And they realized too that their building was sort of on the forefront of gentrification in Brownsville, in Brooklyn, and that it might be strategic for the landlord to have people arrested, to use biometric data against them, and also to evict them, basically to then install a sort of a new class of residents, and that would be part of what they saw as this ongoing process of gentrification. Luckily, they fought back and won, and this technology was never installed. But as I began working with them, and we started to realize that some of this tech had already been deployed in other buildings in New York City and elsewhere. And so that was the formation, that was the genesis of Landlord Tech Watch forming, which works with a few different groups, including the Anti-Eviction Mapping Project, a group in San Francisco called People Power Media, and also the Ocean Hill-Brownsville Alliance, which is now led by Fabian and Chernay, who after winning their case went on to form that group to basically inform different neighbors and different folks in buildings in their neighborhood about potential harms associated with facial recognition and biometric technology being deployed in their buildings. So we have this website where we do a lot of public education. We create public scholarship, basically trying to inform folks about some of the harms associated with landlord technologies, including facial recognition technology and tenant screening. And what we found is it's easy enough perhaps to see that there's a camera that one's landlord installed in one's house or home, but it's a lot harder to know, like, where does the data go? How might that be used against somebody? And also, how does that connect with other forms of data collection? And it's really difficult to follow the data and to kind of figure out what it's doing. And so we began doing a lot of research. We've been reading and been inspired by other work. This is a Washington Post article that facial recognition in public housing in different US cities. And one of the things that this investigative journalist found is that there are now facial recognition programs deployed in public housing in Cincinnati, Omaha, Grand Rapids, Scott County, Jefferson County, Ohio, in Union City, Tennessee, and more. HUD has been supporting the purchase of high-tech surveillance mechanisms through federal crime fighting grants, and has given this money to 27 states to make public housing complexes safer and more secure. That's the idea. And HUD has said that they don't intend for increased surveillance to enable the detection of minor lease violations, but if that did happen, it wouldn't be a violation of the grant terms. So this is definitely a concern. That's in the case of public housing. In New York City and also in San Francisco, also cities like Los Angeles, Berkeley, Santa Monica, and Oakland. We also have rent regulated housing, which could be rent stabilized housing, as in the case of Atlanta Plaza Towers, or rent controlled housing, which is a way to preserve affordable housing in cities like San Francisco, also in New York. And both in public housing and in rent regulated housing, tenants are disproportionately tenants of color and low income. And what's troubling is that in both cases, we're seeing housing be made these sort of laboratories of experimentation for some of this new tech rollout. So this is a quote from at the time, the NYC Deputy Mayor for Housing and Economic Development. She said that, like, we've been saying to the prop tech industry, look, you've got a resource here. Let's talk about how we can make our buildings available to test out some ideas. And so this is from a report that we did about the rollout. You can see in some of the buildings where it's been rolled out in buildings, again, on the edges of gentrification, mostly buildings that are home to tenants of color who are low income, who don't consent deployed. And, even in this quote here, she's conflating tenants with the buildings that they live in, given that it's ultimately tenants rather than the buildings that are experimented on. And this also kind of neglects to mention that tenants aren't given the option to consent into being part of such experiments. And of course, in universities, if we were doing research experiments, people might have to go through, our researchers would have to go through like IRB processes and think about data ethics. This isn't happening when this tech gets rolled out in housing. One of the first cases of its rollout in New York and more generally was in a complex in the Lower East Side in Manhattan called Knickerbocker Village. And this facial recognition technology that was actually initially designed for military uses was deployed in this building nearly 2,000 residents, the majority of whom, 70% of whom are Asian American. And tenants there have complained that the tech actually doesn't work and people have to do these humiliating dances in front of these cameras, which use motion detection as well, to sort of prove that they are who they are to get into their own homes. This one tenant was saying that she was often conflated with her cousin, so it would let her cousin in and not her, which could actually mean that this technology is making people's buildings less secure, less safe. And there are a lot of anxieties about where's the data going? Is it going to the police? Is it going to ICE? And they're not given that information. Another big concern is that facial recognition technology more broadly has been proven to be less accurate in identifying the faces of women of color, in part because a lot of the training that it was tested on is white male faces. So there's a concern that it's being rolled out in places that are disproportionately not home to white men. And some of this tech is really explicit that it wants to be, it's being advertised to landlords as a means of catching tenants for lease violations. And I think this is something that we're seeing perhaps more in public housing. It's not always advantageous in public housing to evict tenants. The housing authorities want tenants to stay in and not have to find new tenants to replace evicted tenants. So in these cases, fines are often more advantageous. And also it just sort of creates this biopolitical context in which tenants feel like they have to perform being the good tenant, knowing that they might be, penalized at any moment. And that creates a lot of anxiety for people, and is not how, a lot of people want to live in the spaces of their own homes. In privately owned housing, there are also these companies that are really explicit that here, install this technology, you can catch tenants for lease violations and then evict them and raise the rent. And so it's, there's a market logic to it. This guy at Tiemann has, I think, over like 700 cameras installed throughout New York City right now. And part of the market logic means you evict tenants, you raise their rents, and then you can rent those buildings for more money and make more money. When it comes to rent regulated buildings, we've seen a lot of tenants scared and unsure if the technology that's being deployed is intended to remove rent control status, to get tenants out, perhaps split buildings and turn them into condos and remove rent control. So in the case of rent stabilization or rent control, where there is a sort of fear that tenants are expressing that the tech is being used perhaps to gentrify neighborhoods and remove affordable housing. But I'm going to just conclude here by saying, there is no database about where all of this is being deployed. There isn't a way to, I've tried doing public record requests to multiple cities to figure out like how many cameras are deployed in rent regulated buildings. Cities aren't collecting this. You can get data about what's going on in HUD buildings, but generally not in privately owned rent regulated buildings. And that's why we've been trying to collect some of this data to better understand what's happening. We've got this survey that we've been administering for 5 years now, basically asking a series of questions about what's going on in people's buildings. And a lot of the quotes that I've been showing you throughout this presentation come from that. These are just, you can see where people have submitted responses, including even responses here about facial recognition now being deployed by Veritas, who was the landlord, the big landlord in San Francisco that I showed you initially. But in some of our reports and writing, we have seen that, there are different, there are attempts, for instance, the No Biometric Barriers to Housing Act, which was introduced by Yvette Clarke, which would outlaw facial recognition in public housing. So we're seeing, we're hoping that moves forward. There are facial recognition bans in a number of cities. San Francisco was the first to ban facial recognition, which means that facial recognition can't be used in public housing in those cities because they can't be used in government contexts. And then there are other tenant protections that we're looking at in California and New York that are also grounds for perhaps keeping some of this at bay. So I think there's a really growing need to kind of do this sort of legal research and litigate against some of this. And at the same time, tenants are on the ground organizing to kind of keep this out of their homes, waiting for kind of sometimes folks in lawyers and different policy advocates collectively. So I want to end here and yeah, looking forward to Q&A.
Thank you very much for that presentation, Dr. McElroy. So we're going to open it up for Q&A. And does anyone have a question? We have 2 hands in the back.
Hi, apologies in advance if my question's a little long-winded. Does the existing FHA analytical framework provide meaningful opportunity to identify and hold accountable discriminatory housing practices when adaptive AI technologies specifically are used? Finding actors liable for discriminatory practices resulting from adaptive AIs, which are initially coded according to non-discriminatory policies, but which later self-modify their code in discriminatory ways, would tend to push these new technologies out of the market. However, not finding actors liable under these circumstances seems untenable, as in that would as well allow further perpetuation of housing segregation. Is there a way to balance these two competing needs of the modern housing market under the existing Fair Housing Act framework? And if not, how will the Act's framework need to change?
Attorney Epstein.
I just want to make sure I get the two interests that you're concerned about straight. So you're concerned about pushing people out of the market, and is the microphone gone already? Let's make sure I understand before I answer.
I'm interested in how the existing framework would balance the needs of a modern housing market to be responsive to such as adaptive AIs that we've seen companies trying to implement here, but also the need of the market to provide fair housing opportunities when the adaptive AI technology themselves are able to modify in discriminatory ways.
Got it. I appreciate it. Okay, so I think there are two questions here. The first is whether the Fair Housing Act provides an appropriate or sufficient framework, and the second is whether it balances those interests. As to the first question, as I mentioned before, and I think this is true, the Fair Housing Act is one of the most robust mechanisms for enforcing, for dealing with algorithmic discrimination, in large part because it allows for disparate impact liability. So I do think it is a good starting point. There are many places for improvement. And I mentioned some of those before as well, including a private right of action for algorithmic discrimination specifically, in case something like CoreLogic happens, where you don't have you have a court who says someone is not covered under the scope of the FHA. As to balancing those interests, I don't really see an issue there. Companies that are unregulated they're gonna do the wrong thing, but there's plenty of room to make money, and I don't think, maybe this is my own biases here, but I don't think that they're gonna make money if you have regulations that require non-discriminatory conduct, impact assessments, things like that. I don't think there's really much risk of pushing people out of the market.
Dr. McElroy, did you want to comment?
No, I stand by what was just said. So.
Okay, great, thank you. We saw a second question in the audience. Yes.
So how does predictive analytics affect the way landlords assess risk when renting to new renters, and how would that affect tenants who might be unfairly categorized?
Sure. So predictive analytics will take into account things like prior criminal history and credit scores and potentially at prior evictions, all things that that may have to do with like, let's take over criminalization. And as I mentioned before, with credit history, it's already it is already biased data. So when you take those things into account, it's going to replicate those same results. And then tenant screening companies will often use those, like it'll produce a score or a yes or no, and there won't be a meaningful opportunity or for someone to respond, or there won't be an independent assessment done after that. So you're taking something that is very, very likely and has been proven to have multiple factors that have proven to be discriminatory. You're not reviewing them, and you're providing like a green light, red light. So it's gonna result in Black people, other people of color, and not being denied housing more often than white people.
So I actually have a question that I would love to pose. Excuse me. One, perhaps that Dr. McElroy you might want to comment on, or perhaps from your perspective, litigating these cases you might want to comment. So, understanding right AI's effects on home seekers, and so a theme of the symposium includes progress and predictions. And so I'm just curious, from either of your perspectives. Communities can actively participate in shaping the use of AI in housing to ensure that it aligns not with just the tenant home seekers experience, but both landlords, right? Because landlords are also a part of the community, at least perhaps smaller landlords. And so that both landlords can get what they need in a fair way, and that tenants and communities can also get what they need in a fair way. And so the first panel referenced, I think it was Professor Kelly referenced movement lawyering. And so I'm just curious, right, movement lawyering being the idea that attorneys are but one tool in the toolbox for advocacy and strategic change on these issues. And so all of this in consideration, right, of the breadth of the different areas that AI is affecting. And so I'm just curious, do you have specific examples from your work with tenants that you might be able to speak to, or from your work as, you know, a litigator on these issues? And Dr. McElroy, I'll let you comment first if you would like.
Okay, yeah, sure. Yeah, no, that's a great question. And I think kind of connects to the previous question in a way too, in that, I mean, one of the things that also can be a mark against somebody, for instance, in predictive analytics, or it's not in predictive analytics, but in tenant screening, is even if somebody's had an abusive landlord and has filed a lawsuit against that landlord, they might still be in the database that gets drawn from in the case of, for instance, LexisNexis, which is the primary data broker that tenant screening companies use. They'll just input that data. So even if somebody hasn't been evicted, but if they've been the subject of you know, unfair practices in housing, they might have a harder time finding housing in the future. And so I think what we're seeing is court history records to be part of the tenant screening algorithm. There's a lot of pushback against that. I think that in the case of tenant organizing, often that happens with tenants who are already living in, given happens before somebody moves in. So I think we're still kind of facing this barrier of needing to bring together a broader kind of coalitional space amongst those who have been subject to unfair tenant screening reports, and those who are facing discrimination through kind of new technologies in the space of their own homes. But I think tenants want a bigger say and a bigger voice we're seeing more of a voice amongst those already living in buildings rather than those who have been unfairly kept out of buildings. The lawsuits become more known, but tenants often don't know they can even request data as to why they were rejected for moving into a given place in the first place. But yeah, I think there's a call to better regulate and curb, and also produce information as to how this data might be used against tenants, and to bring people together across the sort of screening, and then when somebody's already in the building, discrimination landscape. Yeah, I'll turn it over to Attorney Epstein.
Yeah, thank you.
Yeah, I think that's a great question. The dialogue between landlords and tenants is really important because you want to make sure that you come up with regulations and advocate for regulations that are feasible and cost effective for landlords that are interested in applying them. And landlords can voluntarily do it as well. So taking a step back, community organizing in this area is really critical. And litigation is often the tool of last resort and just one aspect of movement lawyering. And so making sure you have those community organizations who foster that dialogue can be really fruitful.
Mm-hmm. Thank you. Any other questions in the audience before we end here? Oh, just kidding. We do not have time for any further questions. We're going to break for lunch. Addie, do you have anything that you want to add before we break for lunch?
So if you have never been to an event in here, we tend to break lunch in half so that it's not just a total rush to the back of the room. So what I'm going to do is I'm going to have up to that first set of double doors right there can get up, and you guys can make your way to the back of the room. Right out to the left will be where all the lunch is set up, and then in like 2 or 3 minutes we'll have the back half of the room get up. You can get up now. Thank you.
Okay, thank you. Thank you to our speakers.
Thank you.